Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome, everybody, to another episode of our Curious Amalgam. I'm Sergei Zaslavsky. The title of today's episode is What's New in U.S. Vertical Merger Enforcement? A look at the UnitedHealth-Change and Illumina Grail merger decisions. Few antitrust cases attract as much attention as merger trials. And while most merger challenges involve horizontal mergers between competitors, the government recently tried to block two vertical mergers, or mergers between firms at different levels of the supply chain, the Illumina Grail merger and the UnitedHealth-Change merger. The government lost both of these merger challenges, which of course comes on the heels of the government losing its only other vertical merger trial in the modern era, AT&T Time Warner, 4 years ago. There has been a lot of debate about merger enforcement generally and vertical mergers specifically, and we wanted to talk about these two recent cases and see what lessons we can draw from these trials. Joining me today to explore these important developments is Jaclyn Phillips. Hi, Jaclyn.
Hi, Sergei.
Jaclyn, who is our guest today?
Today, we are going to hear about these issues from Sara Razi, who experienced them firsthand while representing Change in its $13.8 billion acquisition by UnitedHealth Group. Sara is a partner at Simpson Thacher, and she is global chair of Simpson's Antitrust and Trade Regulation practice. Before joining the firm in 2013, Sara was a deputy assistant director at the Federal Trade Commission. Welcome to the podcast, Sara.
Thank you. It's great to be here.
So to set the stage for our listeners, I want to talk about both the transactions we'll be discussing today. Can you give us a brief overview of the UnitedHealth-Change merger challenge?
Absolutely. Especially given that I've spent about the last year and a half of my life working on this case, so it's near and dear to my heart. In January 2021, the parties announced their deal in which Change Healthcare would be acquired by UnitedHealth Group, which we'll refer to today as UHG, and merged with UHG's company called Optum Insight. UHG is a vertically integrated healthcare company with two main subsidiaries. First, there's United Healthcare, which we'll call UHC, which is the largest commercial health insurer in the U.S., covering approximately 50 million people. And second, there's Optum, comprised of three companies, one of which is Optum Insight, that provide a broad range of healthcare-related products and services to external customers as well as UHC. Change was a healthcare technology company formed through a JV with McKesson in 2017, and after that, Change went public pursuant to an IPO. Among the solutions offered by Change to healthcare payers and providers were Change's leading first-pass claims editing product called Claims Extend, and its leading EDI clearinghouse, or medical network, that transmits a very large volume of healthcare claims data between healthcare providers and payers.
And what were the government's main theories on which it challenged the transaction?
Well, I'll first say the strategic rationale for the deal was to bring together Optum Insight and Change's various products, services, and skills in the healthcare tech space, provide for improved business opportunities, but also to benefit healthcare providers and payers through clinical alignment, claims accuracy, and payer payment simplification. So there were clearly some driving benefits for the parties here. And after a year-long second request investigation in February 2022, the DOJ and the states of New York and Minnesota challenged the transaction, seeking to block it in federal court in D.C. And the government offered three separate theories of harm to competition. One was horizontal and two were vertical. And we'll talk about those. I'm happy to kind of walk through them in a moment. I'll just say that trial was held during the first two very hot weeks in August this year in D.C. in front of Judge Carl Nichols in Federal District Court here in D.C.
So before we move on to Illumina Grail, which I'm going to ask you to give us an overview of also, I just want to stay on UnitedChange for just a moment. And if you could give us an overview of what each of the vertical and horizontal theories were to give us some background as we later dig into the specifics of the trial and the parties' defenses.
So at a high level, there was a fairly traditional horizontal claim that the government made. And that was essentially that the combination of Change's first-class claims editing product, Claims Extend, along with a competing product that Optum Insight marketed to payers, would create essentially a monopoly in first-class claims editing in the U.S. And that the combined market share that UHG would have in claims editing post-transaction would be in the roughly 90% range. As a result, the parties proposed to DOJ during the second request investigation a divestiture of Claims Extend, and the government rejected that divestiture as a remedy for the horizontal issue in the case. And as a result, the parties litigated the fix in front of the court. And then separately, there were two vertical theories. They were quite distinct from one another. One involved information misuse, and another involved theories around foreclosure of innovations to rivals of UnitedHealthcare.
Thanks, Sara. And because that is not complicated enough, we wanted to also talk about Illumina Grail. So could you give us an overview of what the issues were and the merger challenge in that case?
Yes. In March 2021, the FTC issued an administrative complaint alleging an unlawful merger agreement by Illumina and Grail. The complaint alleged that Illumina is the dominant provider of a DNA sequencing tool referred to as NGS, or next generation sequencing, which is a necessary input for the development and commercialization of a variety of different applications, but including multi-cancer early detection, or MCED tests, of which Grail was one such firm developing this type of test. Grail's MCED test, known as Galleri, launched as the first test of this type commercially available in the U.S. shortly after the FTC's complaint issued. The government's claims in this case were purely vertical.
And what were the vertical claims in that case? Were they similar to the theories of harm that we saw in the UHG Change merger?
Well, great question. There certainly were some similarities in the input foreclosure theories that the government alleged in the two respective cases. So why don't I start talking through that respective theory in the UHG Change case. So in essence, the government alleged that Optum and Change were both competing to develop their own so-called integrated platforms, essentially platforms that would simplify and align the incentives of payers and providers when processing healthcare claims. And Optum's integrated platform that was in development was called Transparent Network, while Change's was a concept called real-time settlement. And the government alleged that if UHG succeeded in acquiring Change, UHG could foreclose access to these integrated platforms to UHC's rivals and cause a substantial lessening of competition in the alleged markets for sale of commercial insurance. But the court found serious flaws with that theory, which we can talk about in a moment. If you'd like me to go on and talk about what the foreclosure theory was in Illumina Grail, I can describe that for you as well.
Yeah, let's do that just to give our listeners a sense for, what kind of theories the government brings when it brings an input foreclosure theory, which is a common theory of harm in vertical mergers.
In Illumina Grail, the complaint alleged that as the dominant provider of NGS, Illumina had the ability to foreclose Grail's MCED test rivals, and that post-transaction, Illumina would gain the incentive to foreclose those rivals that may pose a significant threat to Grail going forward. The result, as alleged by complaint counsel, would be reduced innovation, and potentially increase prices and reduce choice and quality for MCED tests. Ultimately, significant harms to American consumers and healthcare patients.
I see. And I think you also mentioned there was an information misuse theory of harm as well at play in the UHG merger. Could you tell our listeners both what information misuse theories in general involve and what was the actual claim in the UHG Change merger?
Yes. So the notion of misuse of information is included within the agency's vertical merger guidelines. And the issue is, in essence, that through a vertical merger, the combined firm may gain access to information about its rivals that may give it the incentive or the ability to raise those rivals' costs and thereby decrease competition in the relevant market. And the application that we saw in the UHG Change case was essentially, I would say, probably the government's primary vertical theory in the case. And it goes like this. It's a bit complicated, and I will say it's what the defendants at trial argued was a daisy chain of speculation comprised of multiple different steps. So let me describe what those steps were in essence. First, that Optum, through its control of Change's EDI clearinghouse or medical network on which the healthcare claims are flowing back and forth between providers and payers, would gain incremental access and use rights to claims data of UHC's rivals. That's step one. Step two, Optum will have an incentive to share that data or competitive insights derived from that data with UHC. Third, that rival payers' fear of UHC using their sensitive data or insights from that data would cause those rivals to innovate less in the markets for commercial insurance. And finally, that the relevant insurance markets would become substantially less competitive as a result. But the court found fundamentally that this vertical claim rested on speculation at every level, and that rather the real-world evidence in the case, which was adduced at trial, substantially contradicted the government's theory.
Yeah, I mean, it's a really interesting thing you bring up here, that the real world evidence. I know that was a really big factor in the AT&T Time Warner decision as well, where economists had theories predicting what parties' incentives would be after the merger. But the court looked to real world evidence and tried to test, well, does that comport with real world evidence or not? And found that the real world evidence did not support the government's case. It seems that played a big role in the UHG Change merger as well. Could you talk a little more about that? How you think the potential tension between economic theories and real-world evidence plays out in vertical merger trials generally and UHG Change specifically?
Absolutely. It's a key issue in any vertical case because typically the government will not have the ability to rely on a structural presumption the way that they can in a horizontal merger case. And so in carrying its burden of persuasion, the plaintiff will have to be able to point to facts, not just market structure, but facts in the real world that are predictive of the competitive harms and actions that the government alleges will happen post-merger. And in UHG Change, Judge Carl Nichols cited extensively to AT&T Time Warner, in particular the premise that Section 7 requires the court to make a prediction about the future, and that prediction must be informed by, and these are quotes from AT&T Time Warner, record evidence and a fact-specific showing as to the proposed merger's likely effects on competition. And as a result, and here again I quote, antitrust theory and speculation cannot trump facts. So that was the guiding principle that Judge Nichols had going into his decision in this case. And in this case, because UHG was already vertically integrated prior to the transaction, Optum had a long history and culture of serving customers who were also rivals of UHC. Optum had access to UHC rivals' sensitive data and had long protected it. Therefore, the court was able to look to this relevant real-world evidence to find the government's arguments unfounded and unsupported. And Judge Chappell in Illumina Grail also found complaint counsel's expert opinion to be, and here I quote, mere conjecture based on an assumption lacking in evidentiary support with regard to Illumina's asserted incentives to foreclose. So that was really a major sticking point in that case as well. In terms of takeaways, I believe the government should take this very seriously because we now have 3 judges who've decided vertical merger challenges and really emphasize this need for plaintiffs to do more in order to carry their burden than merely map out a theory and state that there's an incentive and an ability for the defendant to pursue it post-transaction.
What do you think the government would need to do to actually win a vertical merger case, given this case law? Is it just a matter of finding a judge that's more receptive to economic theories? Or do you think it's finding a case where there is some evidence maybe of past conduct that would indicate that the merging party might act anti-competitively in the future? What's kind of the missing ingredient here for the government?
Well, I think that's exactly it. I think it's the fact that the plaintiff needs to be able to show some sort of indicia of past conduct, perhaps where there was a prior acquisition or an event in the marketplace, at least that's relevant to what the incentives and actions taken would be post-transaction once the combination of the firms comes together. And so I think that the same way that defendants in UHG-Change and Illumina Grail were able to point to the government's lack of proof in that regard, but also their track record that ran counter to the allegations that the government was making. That in a future case, perhaps the government will be able to point to past conduct that they think corroborates the concerns that they allege in their complaint. So it really just is a matter of what the relevant facts are. And I don't think it's impossible for the government to find a case that may bear out that way, but it's the burden rests on the government as the plaintiff. And I think the courts are going to hold them to their proof.
Yeah, and it's somewhat comforting that an economic model, not grounded in those facts, isn't gaining traction in these vertical cases. And it's, nice to have decisions laying that out. So this kind of all goes back to the facts. And our next question to you is about those facts and, what we're calling the behavioral fix, and how UHG and Change said that they would deal with the information misuse. So what were those fixes? What was the conduct that really convinced the judge that there wouldn't be a problem here?
Right. So let's take the 2 cases in turn. Let's start again with UHG and Change. There was extensive testimony and argument about UHG's existing firewalls. And the court viewed this in particular as what he called a structural protection that prevented competitively sensitive information, or CSI, from being shared between Optum and UHC. In particular, firewalls are prevalent throughout the healthcare industry, and the court found that this is essentially an industry standard means of protecting CSI in the vertically integrated healthcare tech space. So here again, there was a track record and there was a pattern and practice and long adhered to policy at UHG to protect rival payer CSI, and that Optum not share that CSI with UHC. And in May 2022, United took a further step by issuing guidance to its companies to address the Change transaction specifically and the data sharing principles to apply post-merger. However, the judge didn't view these as behavioral fixes, and really they were not presented as such by defendants. Rather, these were part of the defense to the government's claims that there would be that type of improper information usage in the first instance. And while the government disputed the effectiveness of these policies and also argued that, UHG could just amend or repeal these policies at will, The court nevertheless found that United was in fact likely to preserve these policies in the future, and there were a variety of reputational and financial and legal constraints that would continue to make that so in the post-merger world. And it is true, too, that a couple of months before the trial, UHG issued letters to Change customers, providing commitments that they would continue to abide by stringent CSI data protections and providing those types of reassurances. But in the end, the court didn't rely on this as a quote unquote fix. In fact, the court found that there wasn't a harm that lacked the appropriate structural protections in place that needed to be solved through some sort of a behavioral remedy along those lines. Now, in Illumina Grail, Illumina, for its part, had made a long-term supply commitment to customers, and had this was called the open assurance, I believe, and it was something that Judge Chappell did look to as a basis upon which the rivals of Grail, or the would-be rivals developing MCED tests in the future, could be a short supply of NGS on non-discriminatory terms. And so I do think that that was influential in Judge Chappell's opinion. But again, it wasn't so much a fix that was litigated rather than a decision that each of the judges respectively made that, in fact, the harms that the government alleged were not likely to in fact occur.
Thanks. That distinction is important. And that it brings me to my next question. Here and in Illumina, it sounds like there were good facts that we knew what the parties would do. And because of the way they'd acted in the past, there really was no harm resulting from these deals. But do you have any sense from the way these cases have came out, or any advice for parties about the extent to which behavioral fixes may be a strategy that parties can consider, and how much success they would have, and any advice for thinking that through?
Given that each of the two judges that we're talking about here, and I think the same is true in AT&T Time Warner as well, didn't ultimately rely on a fix as I said, the reason that they became comfortable allowing these deals to close, I don't think that a behavioral fix is necessarily a silver bullet for any defendants in a vertical merger case going forward. However, as we discussed in each of these cases, there was some element to that, and there was at least some conduct and some assurances that had been provided that would help to assuage some of those concerns if the customers had them, putting aside what the judge's ultimate decision and concerns were in that regard. So I think that there is a role for this. I think that it's probably good business sense for a defendant in a vertical merger case to provide assurances to customers. In terms of the legal implications, I would view this more as a belt and suspenders approach, and certainly not the basis on which I would feel confident in most cases, at least, going in and saying, sure, there's yet to be vertical harm here, but that can be allayed through a litigated behavioral remedy. I think the agencies and the courts would be quite unlikely to adopt that as the ultimate reason for approving a vertical deal if they had fundamental concerns structurally about the transaction.
Well, let's shift from talking about behavioral fix to talk about the more traditional structural fix. You mentioned there was a horizontal component to the UHG Change merger as well that was ultimately addressed through a divestiture. Could you tell our listeners a little more about that?
Yes. So, as I mentioned, the parties proposed the divestiture of claims extend to the DOJ during the pre-complaint investigation, but the government declined to allow the merger to proceed on that basis. And so it became the subject of a litigated fix in the district court. And the proposal was to divest Claims Extend, which was Change's market-leading first-pass claims editing software product. And it was the product as between the merging firms, the larger of the two in terms of the market share and its history in the marketplace. So there was no basis on which the government could say that it was the inferior product or it was lacking from that perspective. But the government did argue that the divestiture was insufficient, and basically they had two concerns with it. One was they said that that a standalone firm selling claims extend wouldn't be able to benefit from a full offering, a sort of a bundled offering with other payment accuracy products, such as been the case when Change was selling claims extend. And additionally, they had concerns about the buyer, who was TPG Capital, a private equity firm. And they expressed those concerns to Judge Nichols.
Well, I want to talk particularly about the second concern, the private equity buyer, because I think that's something that's come up a lot in recent discussions. The government has expressed skepticism about private equity divestiture buyers. I think one of the concerns is these buyers may not get the most out of the divested assets, competitively speaking, and may just seek to squeeze out value by cutting costs. At least that's what concern articulated by the government sometimes. Can you tell us how the parties were able to convince the court here that the private equity buyer would put the assets to good use, and what lessons are there for practitioners who are looking at a private equity buyer as a potential solution to a horizontal merger issue?
Sure. I think this is a really important aspect of this case, particularly given the government agency's aversion to private equity buyers and concerns that they've expressed about them, because Judge Nichols actually found that TPG was going to be a great buyer for these assets. I had no concerns at all about the incentives that TPG would have in order to market claims extend very competitively, and in fact to make significant investments in the competitiveness of claims extend going forward. There was a TPG witness who testified live at the trial, and the judge had the opportunity to ask him some questions about his incentives. And of course, that witness was subject to government cross-examination, as were all witnesses at trial, including the company executives who testified. And the judge was persuaded that a private equity company is seeking return on investment, and yet that's a good thing, because typically return on investment requires investment in competitiveness and marketing and successful sales of product in order to get to whatever milestones that the private equity buyer may determine are needed in order to be it exit the asset or hold the asset for a longer period of time. And so, in essence, Judge Nichols aligned the incentives of a PE company with those of a competitive buyer in the marketplace.
Yeah. So sounds similar to the vertical theories. The key was really just having good facts on your side and being able to bring out those facts effectively during trial.
Yes, and also it was a good divestiture. Claims Extend had been very much marketed as a standalone product. It had been exceedingly successful in the hands even of prior buyers before, or prior owners prior to Change having that product and marketing that product. And it was expected that with that history, the same could be true, that once Claims Extend were spun off to TPG Capital, and given TPG's experience in healthcare generally, albeit not in first pass claims editing specifically, but as an investor in healthcare technology, as they were, that there would be a very likely successful path for Claims Extend as an independent company.
Great. Well, let's shift gears a little bit now, and we have a few questions at the end just to allow our listeners to get to know our guest better. So, Sara, why don't you tell us something about yourself that somebody who only knows you professionally may not know?
Well, unfortunately, I don't have a lot of fun facts the way maybe some of your other guests do. But I will tell you, when I'm not doing antitrust law, I am likely watching basketball games. I have 2 teenage sons, both play basketball nearly year round. And in the summer, that's a lot of tournaments on the road and stuff like that. So I am a basketball mom in my spare time. And I have what I call my third child, although he's a dog, but I have a golden doodle, 8 years old, named Hunter, and he takes up a lot of my free time as well.
Man, the dog doesn't play basketball, though. I thought when you said you had a third child and dog, I figured there was going to be some basketball connection as well, but no basketball for the dog.
I have to find care for the dog when I travel to tournaments, so that's the issue.
Okay, that's the connection. All right, well, thank you so much for joining us today, Sara, and thank you for our listeners to tuning in, and please tune in again next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.